He told the judge he'd had 2 or 3 drinks. By the end of this hearing, that number would triple live, on the record, in front of everyone. This is the arraignment of a man charged with driving nearly 3 times over the legal limit, and what starts as a routine guilty plea turns into a masterclass in getting caught lying to a judge who does not miss a beat. We've got a rookie law grad standing in for the real attorney, a $670 restitution bill that the judge flat out refuses to rubber stamp, and a defendant who keeps shrinking the truth every time he opens his mouth until the judge corners him completely. Stick around, because by the end of this, you'll see exactly why honesty is the one thing you can't fake in a courtroom. Let's get into it.
Minor read 26I-000-1691 and 1692. Good morning, counsel.
Good morning, Your Honor. May it please the Honorable Court, Darnell Barton, P83363, on behalf of Mr. David Minor Reed. Sir, can you state your name and phone for the record?
David Minor Reed.
All right, so for purposes of arraignment, first of all, he has 2 charges here. Let me just double check. It looks like a super drunk and they alternatively charged OWI. Is that what happened?
That is correct.
And now he stands mute, waits for a reading on both of those. And then as I understand it now, he's going to plead guilty. I'll just put it on count 2, operating while visibly impaired, with the understanding that the OWI will be dismissed and the super drunk will be dismissed. Is that correct?
That is correct.
Is that what you want to do, Mr. Minor Reed?
Yes, Your Honor.
If you plead guilty to operating while impaired, did he execute an advice of rights form today?
I thought they gave you the other. I'll have them fill it.
Here.
Still. Sorry, we haven't filled it.
All right,
My apologies.
that's okay. Just have your, who's that? Your associate or your boss?
He is my boss. So if I may, this is Garrett Washington. He's I'm with the young lawyers section of the state bar, and we're doing a program called Journey to Attorney. So we're helping young folks.
Nice.
I want to get to.
Are you a lawyer now?
Not yet. He just.
You took the bar?
Not yet. He just graduated Oakland University. So.
Oh, so you gotta go to law
he's
school.
going to the bar. Yep. We have a high school graduate.
That's fantastic.
2 that are taking the bar in July.
That's fantastic.
We're hanging in there.
Mr. Minor Reed, just relax. I just am having a conversation here. I hope you didn't take you out to what's this restitution, Gross Eel, $670?
Yeah, that was.
What's that for?
Okay, quick pause. Did you catch that $670 number he just casually dropped? File that away, because that figure is about to become the entire second act of this hearing. Also worth noting, the guy standing next to the defendant isn't even a licensed attorney yet. He's a law grad shadowing the real lawyer through a state bar mentorship program. That's not a red flag. That's actually a nice detail. Even future lawyers have to start somewhere, and the judge clearly respects it, cracking jokes and welcoming him in. But don't let the friendly small talk fool you. This judge is warming up, not softening up. The second the plea colloquy resumes, the tone is about to shift hard, and that $670 restitution is going to come back to bite the prosecution later.
If you plead guilty to operating while impaired, the possible penalties are as follows: up to $300 fines, 93 days jail, 360 hours community service, court costs are all 4 points, license suspension or revocation in accordance with your record, and your vehicle could be, or might have to be immobilized depending upon your record. You understand that?
Yes, Your Honor.
Did you sign an advice of rights?
Yes, Your Honor.
Did you read it and understand it?
Yes, Your Honor.
If you plead guilty, you'll be giving up all those rights, and we are not going to have a trial of any kind. Do you understand that?
Yes, Your Honor.
Any questions before I ask how you proceed?
No, Your Honor.
To the charge of operating while impaired, how do you plead?
Yes, Your Honor.
Were you operating a motor vehicle in the township of Grosse Ile on January 10th of 2026?
Yes, Your Honor.
And prior to that, did you drink alcohol? And if so, what did you drink and how much?
I believe I had 2 or 3 Jack and Cokes.
What else?
That was it. And then maybe no more than 5. No more than 5 Jack and Cokes.
Okay, you said 2 to 3, and then you said no more than 5.
Yes.
So was it 5 or was it 2?
2 or 3.
It was 5, wasn't it?
It was 2 or 3. So,
I'm just asking how much you had to consume. Just relax.
It's okay. What the judge is asking, he's saying 5. What the judge is asking is how many drinks you have. If you're not sure, you're saying it was less than 5, or are you saying it was only 2 to 3? The judge wants to know. So,
And you want to be honest with the
yes,
judge.
I'm gonna be.
Some people walk in here a lot to tell you the truth and they're not honest.
Yeah,
And we can read through them.
yeah.
So just tell me how many drinks you had.
I had two.
You had 2 Jack and Cokes.
Yes,
Was this at a bar?
yes.
So you're saying you only had 2 shots of alcohol?
But you were drinking one. Judge is asking, and I know you're nervous.
Don't be nervous.
Very good. Judge is saying not just those drinks. What did you have that entire time? So you had a Jack and Coke, you had some beer,
Yeah.
you had a White Claw, whatever it is. Let me know so that we can be on the same page. Share you.
I've had 3 Jack Cokes and I had 3 White Claws.
Okay.
That
It
means
wasn't so hard, was it?
for that BAC, that 2 Jack and Coke does not make sense.
Why were you pulled over by the police?
And there it is. The number just jumped from 2 or 3 to 6 drinks in the span of about 90 seconds. Notice what actually got that answer out of him. It wasn't pressure or threats. It was the judge calmly repeating the question until the story couldn't hold up anymore. This is a textbook moment in any plea colloquy. Judges aren't just checking boxes. They're testing whether the factual basis for a guilty plea actually holds together. If a defendant's own account of events doesn't add up, the judge can reject the plea entirely. So here's a question for you. Do you think the judge already suspected the real number was higher, or did the shift genuinely catch them off guard? Either way, this is the moment the hearing stops being routine paperwork and turns into a real cross-examination.
What do you think you did wrong? Forget what they think. I want to know what you think you did wrong.
First of all, I'm giving you a little.
I know, but why were you pulled over? You were speeding, weaving, swerving? What
He was
happened?
on the side. He actually pulled over for safety on the side of the road. He was the officers came up as he was already inside.
Where were you on the side of the road? What street?
I can't remember, Your Honor. I was following my GPS on my way.
All right, so you pulled over on the side of the road and the officers approached your vehicle?
Yeah.
And did you feel intoxicated at that time?
No, Your Honor.
You didn't? This is a super drunk charge now. Be careful with it. Okay, come on, just tell me the truth.
Yes, Your Honor.
No, I don't want you to lie to me either. I don't want you to guess. This isn't Jeopardy. Stop, listen to me. Just answer my questions truthfully, okay? Your appearance.
Good morning, Your Honor. Matthew Wayne on behalf of the Township of Groseal.
Good morning to you, Mr. Lean.
Thank you.
So after you had 3 White Claws and 3 Jack and Cokes, you're driving in Groseal Township, right?
Yes, Your
What bar were you at?
Honor. I can't remember, Your
Was it on Groseal?
Honor. I believe so.
You don't know?
Oh, okay. I'll just follow my GPS, Your Honor.
Were you drinking by yourself or with somebody?
I was by myself. I was leaving Captain James.
In Wyandotte?
No, Captain James is in Gibraltar.
And you ended up on Groseal?
Just
Okay,
it's on GPS.
okay, and it took you on to Groseal, right?
I believe so.
And-
Oh, sorry. Yes, Your Honor.
And you pulled over because you were kind of feeling at that point that you were lost. Is that true or false?
That's true, Your Honor.
And then police approached your vehicle, right?
Yes, Your Honor.
And they had put you through field sobriety tests, is that right?
Yes, Your Honor.
And then did they administer a PBT on the road to you, a machine, portable machine?
If I may, Your Honor, they did initially and then didn't register, and then I believe he refused the second time after they tried. So then they did a blood draw, and that's how we.
Is that right?
Correct, Your Honor.
And counsel, what were the results of the blood draw?
I believe it was 0.2. I don't have the exact number, sorry, Your Honor, but we would stipulate to what the session.
3.26, Your Honor, I believe.
I'm sorry?
I believe it's 0.26.
That's correct.
All right.
So stipulate.
Let's sit on that number for a second. 0.26. The legal limit in most jurisdictions is 0.08. That means this wasn't a slightly over-the-line situation. This is more than 3 times the legal threshold. Deep into the range, prosecutors and toxicologists usually associate with a super drunk or high back enhancement, which explains why he was originally charged that way before the plea deal. And notice how the story about how he ended up on that road kept shifting to first he can't remember the street, then it's GPS, then he clarifies he was following it to begin with. Small inconsistencies like that don't necessarily mean someone's being deceptive about everything, but they absolutely give a judge reason to slow down and dig deeper, which is exactly what happens next.
Counsel, one thing I'm going to ask that they do, so and I'm not criticizing, I'm going to come back to you here in a second. not you. On these complaints, I need more information. There's no indication what road he was on. You got BAC of 0.17 or higher. There's no indication what street he was on. There's no indication of what it's just a form. And it really needs to be filled in, these blanks. These officers need to fill these in. They don't have what road he was on. They don't have what his blood or blood or intoxilizer results were. I don't look at police reports. It's inappropriate. Are you on probation or parole right now?
No, you're not.
Anybody forced you to plead guilty?
No, you're
Now, how much did you really?
This is such an underrated moment. The judge isn't just grilling the defendant. He's holding the police department accountable too, pointing out that the paperwork is missing basic details like the street name and the actual test results. That matters because a defendant's due process rights depend on a complete, accurate record. Sloppy reports can create real problems down the line, whether for appeals or for future cases the department handles. It's a good reminder that scrutiny in a courtroom cuts in every direction, not just at the person on trial. And now, the judge is doing math out loud, because 3 drinks and 3 White Claws simply does not add up to a 0.26 blood alcohol reading. Something still isn't adding up here, and the judge knows it.
How much did you really drink?
I had 5 Jack Cokes, a couple of shots, and a couple of White Claws. 3 White Claws.
What kind of shots?
I believe they were, honestly, Jameson.
Okay. Why don't you tell me about that before? You're not going to be one of these guys lying to me, are you?
No.
Because a lot of them do. Like, I get the feeling it's either the way I look, talk, or act that most people don't think I'm very intelligent. And I just ask people to be honest with me. You weren't very honest with me. And I don't appreciate that, okay? You made a big mistake. That's really high breathalyzer. You're over 3 times the legal limit. I'm going to accept you're not on probation or parole, you said, correct?
Okay.
Nobody's forced you to plead guilty?
Okay.
I'll accept your plea to operating while impaired.
And there's the real number: 5 Jack and Cokes, a couple of shots, and a couple of White Claws. Nearly triple what he originally claimed. Here's the part that really stands out, though. The judge doesn't lecture him about the drinking itself. He calls out the dishonesty specifically, saying, "You made a big mistake." Not because of the back, but because he wasn't truthful. That's a subtle but important legal distinction. A guilty plea has to be knowing, voluntary, and based on an accurate factual record. A judge accepting a plea while suspecting the defendant is lying about material facts is treading carefully, which is exactly why he keeps pressing until the numbers finally line up with a 0.26 reading. What do you think? Was the defendant genuinely too nervous to be straight with the court, or was he hoping to minimize things and got caught?
I'm ordering a screening and assessment. I'm going to set a bond. The only issue I have here is, how are you guys coming up with $670 in falsified cover?
Yeah, of course, Your Honor.
Yeah, but let me see. I can tell you that for decades here, you can hand it right to my reporter. I can tell you for decades here now, I've been capping the breathalyzers at 150 and the blood draws at 2 1/4. Now, maybe I need to revisit that, but I'm not going to order $670. I mean,
Your Honor, I would just submit, I mean, I understand that,
it's got $670. He's going to get fined and assessed costs, and I don't appreciate him not being truthful with me. He seems like a real nice kid, to be honest with you. I mean, I've seen a lot worse, but
I mean, with respect, Your Honor, but I mean, aside from the defendant's demeanor, I mean, these are just the figures that the township provided. I mean, I believe they provided in honesty. And these are the rates, Your Honor, and that's what my client has. And I understand that of course, the court is well within its rights to depart from that, but that's,
yeah.
to answer your question, Your Honor.
No, Mr. Wayne, I'm not picking on you. I'm just telling you that I get it. I'm just telling you that I'm not going to order. Let me ask you a question. You had 3 officers that had spent overtime on the arrest. They were all overtime. Don't answer that. I mean, that's a lot. three officers, that's a lot. I mean, so tell them that, you know, I'm not giving more than 2.25. And I'm not condoning his conduct. You don't think I'm condoning your conduct, do you? I'm quite sure that we should order a sober link on this.
And Your Honor.
What do you have to say? I'm gonna address bond now. What do you have to say?
Oh, Your Honor, thank you. I was just gonna say, if you'll allow me to allow him to make a statement to you, Honor, whenever we're done with this, I think he wants to address.
This is one of the most quietly important moments in the whole hearing, and it's easy to miss because there's no shouting. The judge is essentially saying, I don't care what number the township hands me, I set my own cap based on years of precedent breathalyzer costs at $150, blood draws at $225, and $670 blows way past that. This is judicial discretion in action. Prosecutors and townships can request whatever restitution figures they want, but the judge has the final say on what's actually reasonable, and here he's pushing back hard, even hinting that 3 officers working overtime on 1 DUI stop might be part of why the number is inflated in the first place. It's a genuinely fair moment he's holding the defendant accountable for lying, while also holding the system accountable for padding the bill. Who do you think has the stronger case here? The township defending its cost figures, or the judge drawing a hard line on what's reasonable?
What do you want to say to?
I just want to say I'm sorry, Your Honor. It was really nervous here at the moment. I'm thinking about my future with my children. Yeah,
Future of your children.
future with my children. That's what-
Okay, but were you thinking about the future of your children when you were driving around over 3 times the legal limit? That's a good question.
No.
What does he do for a living? I'm just curious.
Well, he's a mechanic.
Use your brains, will you?
Yeah.
Okay.
He's saying that because we had a conversation about.
You cannot, $1,000 personal bond, you cannot leave the state without the consent of the court or violate any law. You must appear in court as directed, attend AA 3 times a week. I want you going 3 times a week. I won't put you on a sober limit. This is the first offense, right? No alcohol, no marijuana, no illegal drugs. You cannot leave the state, cannot violate a law. You must appear in court as directed. You don't need to leave the state for any reason, correct?
Oh, yeah.
All right, we'll give you you're gonna then go over to probation, fill out a questionnaire and be interviewed. That's called a screening, and then you're gonna be, or the questionnaire is the screening. And then you're gonna undergo an assessment, and we'll set a sentence date. You'll go over there and you'll get first go down the hall, get your notice. And give you a copy of the bond sheet. I'll put you in here. What do you have for me, Heather? This does not have to be on a gross yield day. We can do this any day. I'd prefer to do some of these on Monday when I've got a retained lawyer, when there's no restitution. If you can find a Monday, we'll just do it at 8:30 and
we have a probation docket on the 20th.
how are you on July 20th at 8:30? I'm asking your lawyer too.
Judge, I'm sorry, you said July 20.
Yeah, it's a Monday at 8:30.
30?
If you can't do it, you can't do it.
I can't do that. Yeah, I'm
How
sorry.
about the 27th? Am I here then? I think I am. Can you do the 27th?
27, yes, actually, we should.
We'll do it the 27th. Did he hand you an A sheet? You're gonna go every 3 times a week. You're gonna have that form signed. And you're gonna come to court, and every time you come to court, you have to bring it with you. You understand all the bond conditions.
Your Honor, I'm sorry, before you proceed, just, I was not, because I had to exit the courtroom and return some documents. I wasn't present for the entirety, but I believe is the factual basis of the plea. Regarding the reason, what brought the defendant to the Grossfield Police Department's attention, he was off the road. A portion of his vehicle was jutting onto the highway. I think that's important because that establishes
Yeah.
the requisite probable cause for the Grossfield Police Department to investigate.
Is that true, sir?
100%.
Is that true?
Yes, Your Honor.
Don't lie to me again, okay? All right. Good luck. We'll see you back here. Nice.
Thank you.
I think it's great what you're doing for this young man back here.
Thank you, Your Honor.
How long have you been a lawyer now?
2019.
You're well polished for a 6 or 7 year lawyer.
Thank you, sir. I appreciate that.
Have a good day.
Thank you, brother.
So let's break down what actually happened here. The defendant pled guilty to operating while impaired, a reduced charge after the original super drunk and standard OE counts were dismissed as part of the plea deal. But the real story wasn't the charge, it was the process. Over the course of this hearing, His own account of how much he'd been drinking climbed from 2 or 3 drinks all the way to 5 Jack and Cokes, multiple shots, and 2 White Claws, a number that finally lined up with the 0.26 blood alcohol reading, more than 3 times the legal limit. The judge accepted the plea, dismissed the higher charges as negotiated and ordered a screening, an assessment, a $1,000 personal bond, and mandatory recovery meetings 3 times a week. And in a genuinely fair twist, the judge also refused to rubber stamp the township's $670 restitution request, capping it based on his own long-standing precedent instead. This case is a real look at how a courtroom actually tests the truth not through dramatic confrontation, but through patient, repeated questioning until the story holds together or falls apart. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.